Greetings, 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 greetings. I am King Clifford Jefferson, descendant of Godfrey the Fifth Caravan Jew, son of folk ruler of Jerusalem. I'm the reincarnation of King Edgar the Peaceful, which we know here at the Third Tip English Church of England as Jesus Christ. It is July 30th, 2025, which is equivalent to the Berber year 2975. I greet you in the name of my queen, Sister Godwinson from the House of Godwinson. I greet you in the name of Archbishop Mountain from the House of Belmont. I greet you in the name of all the heirs, all the predecessors, all the successors, all those who are trying to get an understanding of what it is that we are here and called to do. Thank you all for joining me here today on this marvelous lesson, Birthright Citizenship, what the Supreme Court of the United States said about the King and the English people. Once again, this lecture is called Birthright Citizenship and what the Supreme Court said about the King and the English people in the matter that was on appeal before the Supreme Court, i.e. Trump versus CASA, Trump versus Washington, D.C., and Trump versus New Jersey. Okay? I got a couple of narratives that we're going to play, as well as we're going to go through that Supreme Court and see that the impact that is going to have on the world, as well as the impact it's going to have on the English people. Okay? So it's very important that those who are abrupt with what's going on in the world today, that they'll take their cue from this lesson in regards to what's going to be surely coming their way in regards to deportation, i.e. Decolonization, whatever term you choose to call it, it will be headed your way shortly. So without further ado, let's get started with your marvelous lesson. We're going to do a history of Trump background, his family, and to see that Trump is aware of the circumstances that are involved in the argument that surrounding Executive Order 14160. Okay, so without further ado, while I'm at it, let me just pull right up. If you have any comments, please post them in the chat, as well as like, share, subscribe if you can. All right. Give the people a couple of minutes to get in. Hmm. Okay. Here we go. Let's get started, everyone. This is the matter that is before the Supreme Court that was decided a couple of days ago. Now, this lecture is specifically for the people identified as the descendants of slaves. This lesson is tailored specifically, inclusively, and exclusively for you. This is to protect your right as a citizen or a subject, whatever you choose to call it, here in these lands, all right, as prescribed by the law, okay, as held up by common law, statutory law, as well as just the common sense, all right. So it's very important for us to read between the lines of what's going on. This is Executive Order 14160. So when we read the Supreme Court case, we have no confusion about the arguments raised and what the conclusion dissented by the Chief Justices and what it is that they were not telling you and what the people aren't telling in regards to those who claim to be doing the research will inform you of what's actually took place in the court proceeding. Okay? Hold that thought. Sorry about that. I'm speaking and wasn't on volume. All right, let me go back in and backtrack real quick. Sorry about that. Go back to the executive order. Okay, so this is executive order 14160. That's before the Supreme Court now. All right. Protected the meaning and the value of American citizenship by the authority vested in me as president by the Constitution and laws of the United States of America is hereby ordered that Section 1. The purpose. The privilege of United States citizenship is priceless and profound gift. The 14th Amendment states all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the states wherein they reside. The provisions rightly repudiated the Supreme Court of the United States shameful decision in Dred Scott versus Sanford, which misinterpreted that the Constitution as permanently excluding people of African descent from eligibility for United States citizenship solely based on their race. That is not the standard anymore. As a result of the picture that I'm going to show you again, of course, you didn't hear me talking because the mic was off, but nonetheless, I'll show it again so that you can see. The image that you're going to see on the screen shows you the difference between just sanguineous and just sore right of citizenship. Just sanguineous and just sore right of citizenship. As you can see on the left, just sore which is based upon three types of citizenship in America. All right. The Naturalization Act of 1790, the Immigration Act of 1924, all right, as well as the 14th Amendment, all right. So the Naturalization Act, 14th Amendment, and then the Immigration Act. Those are three ways that guarantees citizenship here in North America, all right. None of those speak to just sanguineous to the to the point and to the fact of the inheritance that you have that was passed down from your heritage based upon the 14th Amendment citizenship in regards to those who emancipated from slavery by the 13th Amendment. Okay? So it's very important to understand that when you're dealing with the rule of law and the rule of blood, the 14th Amendment does encompasses both types of citizenship, but who does it apply to is yet to be answered. Okay, and this is why this lesson is being done today. All right, so you have the rule of law of the land, just soil, being born on the soil, but we all know that just being born on the soil does not in fact make you a citizen, versus the rule of blood, just sanguineous, which does make you a citizen. And in regards to the executive order 1401, 14160, that is the new standard now, that you must in fact have the blood or descend from a parent that's here that has become an American citizen prior to the passing of this enactment of the executive order passed by the president. Okay. Without further ado, let's go into some of the narratives that I had picked out, chosen specifically for this lesson. Sorry for speaking without the screen on. All right. Listen to it.
Morning. Well, this was a big one, wasn't it? This was a big decision. An amazing decision, one that we're very happy about. This morning, the Supreme Court has delivered a monumental victory for the Constitution, the separation of powers, and the rule of law. In striking down the excessive use of nationwide injunctions to interfere with the normal functioning of the executive branch, the Supreme Court has stopped the presidency itself. That's what they've done. And really, it's been an amazing period of time this last hour. There are people elated all over the country. I've seen such happiness and spirit. Sometimes you don't see that, but this case is very important. I was elected on a historic mandate, but in recent months we've seen a handful of radical left judges effectively try to overrule the rightful powers of the president to stop the American people from getting the policies that they voted for in record numbers. It was a grave threat to democracy, frankly, and instead of merely ruling on the immediate cases before them, these judges have attempted to dictate the law for the entire nation. In practice, this meant that if any one of the nearly 700 federal judges disagreed with the policy of a duly elected president of the United States, he or she could block that policy from going into effect, or at least delay it for many years, tie it up in the court system. This was a colossal abuse of power which never occurred in American history prior to recent decades. And we've been hit with more nationwide injunctions than were issued in the entire 20th century together. Think of it, more than the entire 20th century, me. I'm grateful to the Supreme Court for stepping in and solving this very, very big and complex problem, and they've made it very simple. I want to thank Justice Barrett, who wrote the opinion brilliantly, as well as Chief Justice Roberts and Justices Alito, Gorsuch, Kavanaugh, and Thomas. Great people. Thanks for this decision, and thanks to this decision, we can now promptly file to proceed with numerous policies that have been wrongly enjoined on a nationwide basis. And some of the cases we're talking about would be ending birthright citizenship, which now comes to the fore. That was meant for the babies of slaves. It wasn't meant for people trying to scam the system and come into the country on a vacation. This was, in fact, it was the same date, the exact same date, the end of the Civil War. It was meant for the babies of slaves. And
listen to the time era he's referencing. None of the people who's doing coverage on this story has a clue about what's really going on in regards to why this is actually taking place. None of them, even the guy here who's reiterating what was said. None of them are even speaking about the actual case law. Okay, they only based upon what's been reiterated on YouTube. Okay, we're gonna go into that case law because it definitely affects the children of slaves. And I'm telling you, are in fact the English subjects, okay, who was enslaved. All right. So I'm letting you know that even the black people who claim to have some understanding about what they understand about citizenship do not have a clue of what's going on. All right. Very important that you pay attention and strap onto your boots, because this is going to be a mind-blowing experience for those who comprehend. All right. If you don't comprehend, then it won't be a mind-blowing experience. Your mind's already blown because you shot out. Okay, let's get it.
So clean and so obvious, but this lets us go there and finally win that case, because hundreds of thousands of people are pouring into our country under birthright citizenship, and it wasn't meant for that reason. It was meant for the babies of slaves. So thanks to this decision, we can now promptly file to proceed with these numerous policies and those that have been wrongly enjoined on a nationwide basis, including birthright citizenship, ending sanctuary city funding, suspending refugee resettlement, freezing unnecessary funding, stopping federal taxpayers from paying for transgender surgeries, and numerous other priorities of the American people. We have so many of them. I have a whole list. I'm not going to bore you, and I'm going to have Pam get up and say a few words, but there's really, she can talk as long as she wants, because this is a very important decision. This is a decision that covers a tremendous amount of territory. But I want to just thank again the Supreme Court for this ruling. It's a giant. It's a giant. And they should be very proud, and our country should be very proud of the Supreme Court today. Long story.
Okay. Well, I don't even want to hear what he got to say about it, because he don't understand what's going on. Let's get to another narrative who don't understand what's going on. All right. You can look this brother up on YouTube if you want to. All right. In regards to his take on it, but it does no justice. All right. If you don't understand citizenship from just soil and just sanguineous. All right. He apparently only understands it from just soil. Okay. And I'm pretty sure he was born here. All right. I'm pretty sure his citizenship is not based upon any ancestry from any other part of the world based upon blood. All right. If he did, then he will be telling you what I'm telling you. All right. So let's get on. Let's find another narrative. Greetings, Brother McGow from the House of McGow. Glad you're able to join me today.
By the way, so many questions. Should we keep this going, Pam? By the way, so many questions. Should we keep this going, Pam? This is the opposite of Biden. Biden would take a half a question and he'd leave without answering it. You tell me when it gets boring. Okay?
What's going on, everybody? Thank you all for joining me today. If you haven't already, please make sure you hit the like button, subscribe to the channel if you're new to the channel, and most importantly, please make sure that you are following me on Telegram at CD Media Group to help circumvent social media censorship and shadow banning. With the introduction out of the way, let's get into today's news. And today, we have to discuss probably the greatest victory of the Supreme Court in Donald Trump's favor that has DNC lunatics scrambling right now. They have officially put an end to the judicial tyranny that Trump has been dealing with as it pertains to nationwide injunctions. And that comes off of the back of Donald Trump's original executive order on ending birthright citizenship. So what does that all mean? Well, that means this. Right now, as we speak and as I record in this moment, technically speaking, yes, birthright citizenship has 100% been stripped. It is no more in this moment. And today is a great day. All these DNC lunatics are scrambling because they cannot participate in judicial tyranny anymore. They can't do it, meaning those states that didn't challenge Trump's executive order on ending birthright citizenship are now free to implement it, effectively ending birthright citizenship in their state. But then that creates a new conflict that we're going to try to unpack a little bit more as we move forward. You see, because in a place like California, where they're obviously challenging it, if an illegal immigrant child was born here and receives his citizenship, does that citizenship transfer over to, let's say, a state like Texas? Or is his citizenship not recognized if he goes over to Texas? Like I said, we'll try to unpack that a little bit more. That's something that everybody's trying to figure out right now, especially DNC lunatics, because they are scrambling. And I love.
You know why? Because they have no understanding about the difference between citizenship from a just sanguineous and just soil. He only talking about George just like the other individual. That's the only thing that the government knows. That's the only thing that the colonists knows. Why? Because it was never based upon any inheritance of an inheritance passed on from your progenitors. All right. Very important to understand that. Okay. All right. But yet the executive order was based upon those Africans who were enslaved as a result of their race, not because of the color of their skin, but it said as a result of the color of your race, ancestry, genealogy. How many of you know your race, ancestry, genealogy? That matter was not raised in the court. The only matter that was raised in the Supreme Court was based upon preliminary injunctions. That's the only thing that was raised in that Supreme Court, i.e. SCOTUS. All right? They didn't want to deal with if the actual executive order was invalid. They left that up to those class action suits that would be raised by the individuals brought within their respective cases. Okay? So it's very important that you understand what's being said, because if you ask me, even black people are in the same situation as immigrants based upon the argument of just sore. Because just because you're born here does not make you a citizen. Because there's only three ways that an oath of allegiance and a oath of citizenship can be done, which is only based upon those requirements that were established to identify who is a citizen in fact. All right, which we're going to go through. All right, but even if you're black, Negro, colored, if you fit the descriptions that denote to the citizenship required here in North America, then 9 times out of 10, you might be subject to the same enactment of the executive orders in regards to deportation. Okay? Very important to understand that. So I don't care what group, what society, what clique, what campaign, I don't care what it is that you associate. It better have some political backing. Let's get it. Let's find somebody else.
His Attorney General spoke out. Anthony Johnson is standing by with that part of our coverage. Anthony?
Yeah, late this afternoon, we did hear from Senator Kim talking about the fact that his family moved to the United States some 50 years ago. He was reacting to the Supreme Court announcement earlier today and saying, this is not the end of the road.
The reaction to the court's ruling giving the president more leverage when it comes to executive orders and lower court decisions has left a chilling impact on undocumented residents around the country. But New Jersey's Attorney General has stood on the side of those who are trying to find the path to citizenship.
The court very clearly did not address the merits of birthright citizenship. And they, in fact, stayed the executive order for another 30 days for everyone.
Attorney General Matt Platkin adds the president's approach to birthright citizenship is a recipe for chaos on the ground and harm to the states. Local supporters of immigrants agree.
I think to try to call the bluff of an administration that has been hell-bent at ripping sections out of the U.S. Constitution is naive.
New Jersey-based groups serving undocumented residents say the impact of the court's ruling is going to be felt far and wide.
The fact that our kids will not be enrolled in school because there's a fear of, will my kid be picked up, right?
New Jersey is among 22 states that sued over the president's use of an executive order to ban birthright citizenship.
We're going to see more non-cooperation with things that we know are unholy and just wrong, that are hurting people.
This woman has an undocumented spouse and did not want to show her face because she's worried about his safety and sees today's ruling as an attack on people like her husband.
We have to push back, and we have to stand up when something is wrong and say so, and stand up for people who are not able to do that for themselves.
Yeah, supporters of the undocumented immigrants here in the state of New Jersey says the state legislature has to push forward with the Immigrant Trust Act that has been on the table since 2021. And so far, they haven't seen any action on that. They said now is the time to move that act forward. That is the latest.
Okay. All right. None of them really understand what's going on based upon the decision made by the Supreme Court. All right. None of them. Why? Because they don't know.
Sean Diddy Combs' sex trafficking and racketeering trial is coming to.
As a result of them not understanding citizenship, my brothers and sisters. All right. It's very important that you understand citizenship. All right. Very important. I'm going to take you by the hand like a baby. Okay. All right. I'm going to take you by the hand and show you this. That if you are of darker hue, yes. Brother Nunn said, what about the people they terrorized on their own land for centuries? We have to go back that far. I always say, he who writes your books sets your timeline. Time never was when we, as the English people, were not. If the life and time begin when the English people begin, the time will come when we, as the English people, will be no more. We read it in English, but nobody wants to be English. We have the blood of the English, but nobody recognizes the blood of the English because nobody recognizes that you're on English soil. Okay? They recognize it. They ain't telling you that. Why? Because you don't know your history. Okay? The 14th Amendment, Donald Trump said, was exclusively and inclusively for the descendants of emancipated slaves, not slaves, emancipated slaves. When you're emancipated, you're given your freedom. Freedom by the laws of the land. There's only two laws that govern the citizenship of and freedom of the citizens. Okay? That's based upon the Constitution and what the amendments to the Constitution. That meant that some administrative statute that they created, such as Title 8 United States Code 1401. Okay, this is the national, i.e., naturalized clause for citizenship based upon the ceremony that is enacted based upon the oath of allegiance to the flag of what represents the United States. Okay, has nothing to do with rule of blood. Okay, very important. Has nothing to do with that. This is the reason why they never addressed the citizenship clause in the Supreme Court. They only address those who are able to request a preliminary injunction. We call it a bill of peace. Okay, a bill of peace. One person sues on behalf of the whole class as a result of discrimination, defamation, bias, etc. I'm doing that on your behalf. No one recognized that. Why? Because no one recognized the king is back. Donald Trump does. He said he recognized the king. Okay? There's only one king he recognized. That's the Lord and Savior. All right? So just soil and just sanguineous. Just soil determines if you were born on the soil, but it does not protect your citizenship as a result of the Supreme Court's decision. Rule of the blood does protect your citizenship as a result of the decision of the Supreme Court. That was in tune with the Executive Order 14-1601 in regards to the emancipated children of slaves and the right to be recorded as now citizens, not based upon you just being born here or not because of the color of skin, but because of your ancestry, DNA, bloodline. I'm not just saying that. That's what the executive order said. Let's go back to the executive order and read it for ourselves. A true leader will not leave their people in the dark. Okay? Will not leave their people in the dark. They're in the White House. All right? The word blanco is the word for white. It's also go back to the word Balik, and Balik is synonymous with the word black. Okay, so black and white is actually the same word, the same letters. Okay, just spelled different by different people who want you to identify you differently than what you are. Okay, very important to understand what it is that your king is telling you, because I love you very much, and I don't want you to be led astray when the time comes for you to make your decision, because the decision is yours. It's not mine. You have a choice to give your allegiance to your ancestors. That determines your right to be here versus your oath to that flag, which determines your right to be deported. Why? Because it was a treasonous act to depart from the law that was here prior to your declaration to the new law that was implemented through what we call a treasonous act. All right, we must understand how serious this matter is. Okay, let's go down to the definitions. Definition. You can read the entirety of in the scope of it on your own. Now, the Attorney General, Anthony Blinken, which you just seen, was against the executive order that was passed on behalf of Donald Trump and his cabinet, right? But now he's obligated, you know what I'm saying? So he did his best, but it's not going to hold up. Why? Because you are an officer of the cabinet of the executive. Anything the executive officer said, you have to do it, all right? Enforcement. The Secretary of State, the Attorney General, and the Secretary of Homeland Security, and the Commissioner of Social Security should take all appropriate measures, all right, to ensure that the regulation and policies of the respective departments and agencies are consistent with the order, and that no officer, employee, or agent of their respective departments and agencies act or forbid from acting in the manner inconsistent with this order. B, the heads of all, this is the partial injunction, okay? It was suspended for 30 days, all right, as we're going to see in the Supreme Court order. B, all right, so I apologize for that. Oh, I'm sorry. I went past it. Right here. Section and purpose. The purpose of the United States citizenship is a priceless, profound gift. This is the third time I read it. The 14th Amendment states all persons born or naturalized, okay? Born or naturalized. Born or naturalized is the same thing. Just so. Please understand that. It has nothing to do with the blood of your mother or father, okay? This executive order changes that. All right, exclusively and inclusively for those who were emancipated through the 13th Amendment. They're not talking about anybody else, brothers and sisters. They're specifically talking about you. That's in my background. Okay, you. The 14th Amendment, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and other states wherein they reside. The provisions rightfully repudiate the Supreme Court of the United States' shameful decision in Dred Scott versus Sanford, which misinterpreted the Constitution as permanently excluding the people of African descent from eligibility from the United States citizenship solely based on their race. This is based upon their citizenship clause, which was the Naturalization Act of 1790. We could not be citizens under the Naturalization Act of 1790 because that dealt with the color of your skin. Do y'all hear what I'm saying? That dealt with the color of your skin. And the color of your skin had to be white. Okay? Prior to them being in the White House, the only people in that house was those people who were black. So it was called the Black House. But the 14th Amendment has never been interpreted to extend citizenship universally to everyone born in the United States, but not subject to the jurisdiction thereof. Consistent with this understanding, the Congress has further specified through legislative enactment that a person born in the United States and subject to the jurisdiction thereof is a national and a citizen of the United States at birth under Title 8 United States Code 1401, generally mirroring the 14th Amendment text. So they're not the same, brothers and sisters. Okay, how can I make y'all see that the 14th Amendment and the amendment clause of Title 8, Section 1401 of a code enacted to extend to other people identified and trying to become citizens is not the same? Because the 14th Amendment, according to the language under the 14th Amendment, is construed to the common law of England and must be looked at in light of the history of the common law. very important to make the distinction between the 14th Amendment and Title 8 United States Code 1401, which you're going to hear in Supreme Court's argument based upon the dissent given by Chief Justices. Okay? If everyone understands that who's here with me today, please give me a thumbs up and a chat line. Okay? Give me a thumbs up in the chat line. Let's go down. Thank you, Brother Nunley from the House of Nunley. Section 2. It is the policy of the United States that no department or agency of the United States government shall issue documents recognizing United States citizenship or accept documents issued by state, local, or other governments or authorities purporting to recognize United States citizenship to persons. Very, very important. 1. When that person or mother was unlawfully present in the United States and the person's father was not a United States citizen, or lawful permanent resident at the time of that said birth. 2. When that person's mother or present in the United States was lawful but temporary, and that the person's father was not a United States citizen or lawful permanent resident at the time of that said person's birth. Very, very important. They're talking about the status of the mother, Part 2, sequitur being trim. The status of bastards, not the status of those who are of paternal descent, which is a status that you need for inheritance. This is why this is legislative enactment is being enacted, so that we can now receive our inheritance based upon Section 3 and Section 4 of this enactment. Section 3 says the enforcement. The Secretary of State, the Attorney General, and the Secretary of Homeland Security and the Commission of Social Security shall take all appropriate measures to ensure that the regulations and policies of their respective departments and agencies are consistent with the order, and that no officers, employees, or agents of the respective departments and agencies act or forbear from the act in a manner inconsistent with this order. B. The heads of all executive orders, departments, and agencies shall issue public guidances within 30 days of the date of this order regarding this order's implementation with respect to their operations and activities. Definition, very important, as used in this order. Mother means the immediate female biological progenitor. That's A. B. Father means immediate male biological progenitor. All right? They're not talking about anybody else specifically in regards to a true American citizen. They have a clause or a safety clause or a mother clause for those who were born based upon Title 8 United States Code 14.1 prior to the 30 days of the enactment of this enactment of the Executive Order 14.160. Okay? That still does not speak for those whose citizenship that are not associated with Title 8 United States Code 1401, but exclusively the 14th Amendment, which the Supreme Court did not address. Okay? None of them want to address the 14th Amendment citizenship clause in regards to the history of citizens within that clause, which must be looked at in light of the English common law. Very important for you to understand that, because that's where we're going next. General provisions. Nothing in this order shall be construed to impair or otherwise affect the authority granted by the law to any executive department or agency or the head thereof, or any or 2, functions of the director, officers, management, budget relating to the budgetary, administrative, or legislative proposals. This order should be implemented. Consistent for itself. Implemented consistent with the applicable laws for itself. Applicable laws are subject to the availability of appropriations. All right, since we understand the Executive Order 14160, that's before the Supreme Court, that was stayed based upon a request for an international or national injunction that was denied by the Supreme Court. And the only way an injunction could be brought or submitted is based upon those classes that were coming within in their purport. Okay? So you must raise the argument, and the state or any state is not in that position to do so, or else they would succeeded by what the Supreme Court stated in their dissent, which we're going to go through very shortly. Okay, so let's look at the background of Donald Trump, because we understand that he's not speaking on behalf of the citizenship that was determined by the Naturalization Act of 1790. Okay, he's not speaking on behalf of that. The executive order was not based upon that terminology of the Naturalization Act in 1790, as we can see. All right. It spoke about the 14th Amendment in regards to those emancipated slaves who were freed by the 13th Amendment. Okay. So let's revisit the Naturalization Act of 1790, and just in case those don't want to visit it, because you got to use one of the three: the Naturalization Act, the 14th Amendment, or the Immigration Act. Okay, and the only thing else left out there that was there prior to that was the Calvin's case. Okay, which goes all the way back to the Elizabeth's religious settlement. All right, and you don't go back that far, because the birthright and heritage don't go past the second generation. All right, very important. The Naturalization Act of 1790 was a law of the United States Congress that set the first uniform rules of granting the United States citizenship by naturalization. Okay, this is before Title 8, United States Code 1401. Before that, the law limitation naturalization to be free white persons. You hear that, y'all? Of good character. This eliminated ambiguity on how to treat newcomers, given that free black people have been allowed citizenship at the state level in many states. So we were already free people of the states before they enacted the Naturalization Act of 1790 for the United States. You heard it right there. Did everyone hear that? Please give me a thumbs up in the chat line if you heard that. All right. So it says the law limited naturalization to free white persons of good character. This eliminated ambiguity on how to treat newcomers, given that free black people have been allowed citizenship at the state level in many states. Okay? Very important that y'all get that understanding before we go on. All right? Congress models the act on the Plantation Act of 1740, a British Parliament. Did you hear that? A British Parliament. So we're not cutting no corners here. No corners are we cutting. Why? Supreme Court didn't cut no corners. I'm not going to cut any corners. They understand the power of citizenship. They understand the power of allegiance. All right? Congress modeled the act on the Plantation Act. We know a Plantation Act is an act dealing with those who immigrated and now took residence on plantations. Okay? And that goes back to 1740 under the British Parliament, that was officially titled an Act for Naturalizing Such Foreign Protestants and other therein mentioned are settled or still settled in His Majesty's colonies in America, and use its provisions concerning time, oath of allegiance, the process of swearing before a judge, etc. I hope y'all see where I'm going with this, all right? We're talking about oath of allegiance, coronation oath, all right, oath of office, all right? Where did you take your allegiance to based upon those who protect you in that oath of office, all right? Because your pledge means you give it away. When you pledge to something, you give something away. That's an oath. All right? Very important to understand. You got the Naturalization Act of 1790, which is rooted in the Plantation Act of 1740, that deal with those naturalized citizens that came under the Citizenship Act of 1740 on a German king, King George II. All right? Under the British Parliament, not English Parliament, but British Parliament. British Parliament resulted in the Act of 1706 and 1707 under the England and Scotland, calling themselves the British Great Britain, when prior to that, it was simply called the Parliament of England and the Parliament of Scotland, 1215, 1235. You don't understand that? Please watch my last lesson to bring that clarity. Now we have the 14th Amendment, exclusively and exclusively for those people identified as Africans or Black people who had a race that they did not know. What race was that you did not know? It was English, my brothers and sisters. For all you in this background, your race was English. Englishmen, English women. They did not include you in the Citizenship and Naturalization Act of 1790. They did not include you in the Immigration Act of 1924 and the ones prior to that. All right? You already had your protection. You just got duped because they enslaved you during a time of slavery. All right? Which automatically made you a citizen as a result of that history that they don't want to revisit. All right? But guess what? They have to because it's on the record. The 14th Amendment to the United States Constitution was adopted on July 9th, 1868 as the Reconstruction Amendment, considered one of the most consequential amendments in addressing the citizenship rights of equal protection under the law at all levels of government. Because we understand when they created the Naturalization Act of 1790, we were already citizens on the state level before they decided to overthrow the government on the state level, which was the government of the crown that was governing the crown colonies and the crown subjects who were different from crown citizens. Okay? We had a birthright. The 14th Amendment was a response to the issue affecting only, exclusively, and inclusively freed slaves following the American Civil War, and the passage was bitterly contested. Why? Because they did not want us to go back to our inheritance. They didn't want that, my brothers and sisters. All right, so when they freed us, they didn't want to grant us any title nobility because the Constitution forbids title nobility to be granted because you can't grant it as an inheritance. You gave it up by way of waiving your right to become wards of the states. All right, very important. Because the 14th Amendment must be construed to United States versus Juan Kim Art, which was brought up in the Supreme Court case. They did not go in depth in it like we are going to, but nonetheless, it was brought up. United States versus Juan Kim Art. This is Wikipedia. All right? When we read it, it ain't going to say shit about Title 8 United States Code 1401. Nothing whatsoever. The holding of that, in spite of what they were talking about in regards to Juan Kim Art, they was dealing with his citizenship under Title 8 United States Code 1401 under the Immigration Acts that allow him to become a naturalized citizen. This case doesn't deal with naturalizing. It deals with the right of citizenship that's construed to the citizenship that was on the state level prior to the states and the United States unifying and becoming one body of politics under what they call a revolutionary government or a revolutionary republic. This is a law or a government of laws established outside of the law or a result of overthrowing the law that was already in place. The holding is that 1A, a child born in the United States to alien parents is a citizen. 2, the phrase subject to the jurisdiction thereof should be interpreted in light of what? The common law. The common law. Okay, now they didn't go in depth in that because they didn't want to give you too much. All right, but we are. We are. Let's get it. And then you got the Immigration Act of 1924. Let's revisit that. So take your pick, brothers and sisters. That's your 3. I'm going to show you the ones that we have. which is mentioned in Juan Kim Art's case law. Okay, it's called the legislative enactment by our ancestors is actually called Didnatus Otramayer. His Majesty law to govern our right and heritage overseas. Okay? Immigration Act. The Immigration Act, we don't even go into that. We know what Immigration Act means. An act to deal with naturalizing immigrants. Okay? Very important. We got 3 cases to qualify that. Anyway, Ahmad Hassan, United States versus Juan Kim Art, as well as United States versus Sting Tuck or King Du, which we're going to talk about in a second. All right. So everyone, please don't use your interest in this case because it's very important based upon the impact it's going to have based upon your understanding that I'm about to throw on you right now. All right. So we see the Immigration Act, the 14th Amendment, and the Naturalization Act of 1790. Okay. We can't use the Immigration Act because we're not immigrants. We can't use the Naturalization Act because that was exclusive for white people. All right. We're not white people. We're a black people, based upon a lack of a better term, but yet we got a race based upon the identity of black people, which we don't know, all right? And I'm telling you that it's English. Why? Because laws are already in place based upon United States versus Juan Kim Art, which was supposed to be construed to the common law of England in light of the history of the common law. And the common law goes back to who? Henry II of the Plantagenet crown, son of Godfrey V, Count of Anjou, son of Folk, ruler of Jerusalem. How I know that? Why? Because that's my ancestry. It is also your ancestry. How I know it? Our ancestors passed legislation to validate it. Not just soil, but just sanguineous. All right? De Natus Otramayer, also known as the Statute of Children Born Abroad Act of 1350, was an English statute during the reign of Edward III, son of Edward II, son of Edward I, son of Henry III, son of John, son of Godfrey V, Count of Anjou, son of Folk, ruler of Jerusalem. It regulated rights of those born overseas and was an English early precursor of British nationality law and others. Did you hear that? It was an early precursor of British nationality law and others. So it preceded British laws in regards to nationals, i.e. the laws naturalizing immigrants, all right, of 1740, which we just read, as well as those that took place prior to that as a result of what took place in the 100-Year War, or the War of the Roses, which was a war as a result of anarchy or civil government that goes all the way back to the First, Second, and Third Barren War. Okay? It addressed the issue of inheritance by foreign-born children of topical problems. So not just you being born on the soil, but it addressed the inheritance of you being on the soil. Okay? This was a king of England. Okay? The statute of Edward III was invoked over 200 years later in 2 matters. It was in the first of those, it did not prove effective since the outcome went into the other direction. But in the second, it was significant in the debate of the succession of Elizabeth I from the House of Tudors. It was thought by some to be the telling against claimants of the House of Stuarts in Calvin's case, which I just mentioned. I just mentioned it. All right. So all these cases were preceded by the cases that originated under Scottish kings, under British monarchs that stole the citizenship from the true heirs or the true descendants who had a birthright inheritance and based upon the soil or the estates of land, which we're going to talk about now. All right. This Pleading Act was the Pleading Act of 1350. Okay. The Pleading Act of 1350. Why do I say that? Let's go to Juan Kim Art and see if they talk about this case. Okay? Since we see in the 14th Amendment that it's exclusively and inclusively denotes to all of you back here behind me. Only you, nobody else. Okay? But you don't know that you are children born abroad. Okay? Being as a result of you misunderstanding what land that you're on. Okay? They got you thinking you come from Africa when you actually belong here. All right? This at one time, I can agree, was connected to that continent that was not called Africa. Okay, we're not going to get into the scope of that argument right now because it's not backed by political, geological, or political law. Okay, very important. So, De Natis Ultramarine was a law concerning children born abroad. Okay, it was a precursor for British nationality as well as those that originated after that, which was the Naturalization Act of 1790, the Immigration Act, as well as the 14th Amendment. All right, very important. Now, let's go to Dred Scott case and see if Dred Scott case mentions this act of 1350. Okay, very important. Let's see. Why would this case mention His Majesty's enactment in regards to inheritance that we have here in England that they now call the United States? Okay, you are in England, but as a result, you don't know that. You gave it up your birthright. Everyone hold that thought. Pull up that case. United States versus 1 Camargue, 1898. Both in England and the United States, indeed, statutes have been passed at various times enacting that certain entities born abroad of English subject or of an American citizen, respectively, should inherit to some extent at least the right of their parents. You hear that? But those statutes apply only to the cases coming within their purport. So if you don't raise the argument is waived. How many of you raised that argument in regard to you saying you are English subject born in America or American subject born in England? Vice versa. How many of you raised that argument? All right. If you haven't raised it, you're not raising an argument in the court of law, then you have not come into that purport in lieu of seeking remedy. All right. Concerning it in either country as affecting citizenship a person born within this dominion. So once again, both in England and in the United States, indeed, statutes have been passed at various times enacting that certain issues born abroad of English subjects or American citizens. So that means that American citizens were English subjects. Can we say that? If that's safe to say? If that's safe to say that American citizens are in fact English subjects. And English subjects are in fact American citizens, respectively, and should inherit to some extent at least the rights of their parents. All right. But those statutes apply only to cases. They're not talking about common law. And one, we're reading the common law, and now they're talking about statutes applied only to cases coming within the report. So if you don't find a statute relative to the common law in regards to the birthright that you say you have a right to in regards to an estate and land that's on all the land, i.e. allodial land, then guess what? You don't have a right to be here. All right? So the first statute in America and England enacted in regards to an inheritance, some type of estate for an American citizen or an English subject was the earliest statute that was passed in the reign of Edward III and the Rose of Parliament, Edward III, 1343. We're not even talking about the 1350. They're going back before that, 1343. Do everyone see that? It stated that. Okay? They just don't apply there in England, but they apply here in America. Before these times, there has been great doubt and difficulty. Now, we've been through this statute over We've been through this case law over and over and over and over, and you have been none the wise. Okay? Edward III, the King of England, our ancestor, which I am fitting the tenure as the King of England, as your descendant, your predecessor, your ancestor before these times, there has been great doubt and difficulty among the lords of this realm and the commons, as well men of the law as others, whether children who are born in parts beyond the sea ought to bear inheritance after the death of their ancestors in England, because no certain laws has been thereon ordained. This is called the Statutes of Waste. Okay? The Statutes of Waste. I'm not even going to get into that because it would be what they say. It would be for naught. You know, I got enough to deal with now than to just go back and rehash something that you should understand. So, and it said, and by the king and lords and commons, it was unanimously, right, so. And by the king, and by the king and lords and commons, it was unanimously agreed that there was no manner of doubt that the children of our Lord, the king, do you hear the language of our Lord, the king, of our Lord, the king? This is the image of a Christ-like being. All right? An elder, an anointed person that was considered to be a Lord, a God on earth. There was no divine right of kings. I talked about that. All right. There was no manner of doubt that the children of our Lord, the King, whether they were born on this side of the sea or beyond the sea, should bear the inheritance of their ancestors. And in regards to others, it was agreed in this parliament that they should also inherit wherever they might be born in the service of the king. You hear that? It's a package deal. But because Parliament was about to depart and that the business demanded great advisement and great deliberation, how it should be best and most surely done, the making of the statute was put off to the next Parliament, by reason, apparently, of the prevalence of the plague called the Black Plague in England. No act upon the subject was passed until the Edward III in 1350, when Parliament passed an act entitled A Statute for those who were born in parts beyond the sea, but which, after reciting that some people be in doubt if the children born in this part beyond the sea out of the legions of England, it didn't say Scotland, it didn't say Ireland, it didn't say Morocco, it didn't say any of that. It said England should be able to demand any inheritance within the same legions or not, whereof a petition was put in the Parliament, called a petition, of the Edward III, and as not at the same time wholly assented, it was agreed and affirmed that the law of the Crown of England is and always has been such that the children of the kings of England, and whoever part they be born, whether it was a king sitting over there in what they call Great Britain now, or a king of England sitting over here in what we call America now, that in England or elsewhere be able and ought to bear the inheritance after the death of their ancestors. I repeat, that the law of the Crown of England, the Crown of England is nothing more than a station. All right? I don't got time to define it over and over and over again. But it said that the law of the Crown of England, it didn't say the law of the King of England, it said the law of the Crown of England. The king represents the crown. It's called Crown Land, which is an entail state personified by the king, i.e. the crown, i.e. the Lord. You call it incarnate, I call it incorporate. I call it personified. And it always has been such that the children of the kings of England, and whatever part they be born, in England or elsewhere, be able and ought to bear the inheritance after the death of what? Their ancestors. 2. It was also agreed that certain persons named, which were born beyond the sea, out of the legions of England, should be and from henceforth able to have and enjoy their inheritance after the death of their ancestors in all parts where the legions of England, as well as those that should be born within the same legion. This is called littoral rights or referendum rights. Once again, littoral rights or referendum rights. These are rights involving estates and land, not real estate. Estates and land, which means subsurface rights, water, air, and subsurface, surface, water, and air rights. These are all associated with estates and land, my brothers and sisters. Okay, so as we see that the Act 1350 that we see in United States versus 1 Kim Art, which was a statute passed for England and America for English subjects or English American citizens, and they are in fact one and the same. All right, they are in fact one and the same. We can go to United States versus Shinkum Du for that. Right here. United States versus Sing Tuck or Du. But it is said that the did not prove before the immigration officers that they were citizens, that some simply alleged the fact, while others said nothing, that they were told that if they would give the names of 2 witnesses, their testimony would be taken and considered. But what provisions of law is there for compelling the attendance of witnesses before such immigration officers, or for the taking of dispositions, or of what avail would be an ex parte inquiry of such a witness? Must an American citizen seeking to return to this, his native land, be compelled to bring with him 2 witnesses to prove this place of birth, or else be denied his right to return and all opportunity of establishing his citizenship in course of his country? No such rule is enforced against an American citizen of Anglo-Saxon descent. And if this be as claimed a government of laws and not of men, I do not think it should be enforced against an American citizen of Chinese descent. That's in lieu of what we call a naturalization process, okay? Because a naturalized a Chinese, nor light-skinned Chinese, nor dark-skinned Arab fall under the classification of a citizenship under the Naturalization Act as determined by the legislation enactment, or can he classify as a member of a group dealing with genealogy or ethnicity until that test is done, okay? We see that argument in Emre Ahmad Hassan. Let's see. If everybody keeping up, please give me a thumbs up in the chat line. And Ray Ahmad Hassan, this is in the District Court of Michigan. It says to summarize the approach which must be followed in deciding where a particular person is applying for citizenship is a white person within the meaning of the statute, and that statute is Naturalization Act of 1790 as interpreted by the Supreme Court. It is necessary to determine first the particular group or racial subdivision to which the individual belongs. You cannot do that with the Immigration Act of 1924. You cannot do that with the National Act of 1790. The only way you can do that is with the 14th Amendment, because that was based upon race as intended by the Executive Order 14160. All right? In practical effects, proof of this fact is a matter of what? Genealogy. An individual who presents an aberration from the color of a skin and the group of which he is a member, such as a light-skinned Chinese, Japanese, or a dark-skinned Anglo-Saxon, does not thereby acquire a different status under the Act from other members of his group. So whether you're light-skinned or dark-skinned, whether you're white or black, brown or yellow, that has nothing to do with your ethnicity, your genealogy, as denoted to your allegiance to your nation, or based upon some enacted legislative enactment by a group of political thinkers who thinking only about themselves based upon those who are within the group as distinguished in the Naturalization Act of 1790, thereby acquiring a different status under the act from other members of other groups. Okay? Once again, it says, a light-skinned Chinese, Japanese, or dark-skinned Anglo-Saxon. It said dark-skinned Anglo-Saxon. Didn't it say that? So we don't just associate ourselves with Anglo-Saxon as a result of just being dark-skinned, even though we are. We associated ourselves with Anglo-Saxon because the 14th Amendment said we supposed to. All right, because that's the English law that originated from the group called Anglo-Saxon, which under the 1911 Encyclopedia Britannica, they were called Berbers, okay? They were called Berbers. So, of course, when an individual applying for citizenship has the skin of a different color other than the dark-skinned Anglo-Saxon or light-skinned Chinese or Arab, okay, then a user role for the members of the group from which he claims to be, or which he claims to come, a strong burden of proof rests upon him to show by the usual method of proving genealogy that he is in fact a member of that group. This is what the Supreme Court does not want to address. Okay? They do not want to address, especially when you're talking about a national and injunction. Okay? After the individual has been traced into his group, then the second question which courts must answer is whether the member of that group as a whole or white person as Congress understood it in the term of the Naturalization Act of 1790, which was the first enacted by that statute. And deciding the latter question based upon the language in the Naturalization Act of 1790, not the 14th Amendment, not the Immigration Act of 1924, but the Naturalization Act of 1790, when they were first enacted in the statute, they decide in the latter question, the test is not how the group in question will be classified by ethnologists who have made a study of racial origin, but rather which group of people then living in 1790 with the characteristics then existing which were intended by Congress to be classified as white persons. Applying these principles, the court finds that petitioner or any other petitioner petitioning for citizenship, whether you're white, black, colored, if it's not done based upon the 14th Amendment, you have no status at all. And that Arabs or white people or any other person for that matter, based upon our understanding, are not citizens in the meaning of the case law that we just read. Okay? Because the only two American citizens that don't need no proof were what? The Anglo-Saxon. And the Anglo-Saxon was not based upon the color of skin, but genealogy, ethnicity, and origin. Okay? With that, let's move on to the Supreme Court case. You mean tell me I only got 3 thumbs up? Okay, when you read the Supreme Court, you'll change your mind. Before we do that, let's look at Trump family. Trump. Trump family descendants and ancestry had nothing to do with what the meaning of the Naturalization Act of 1790 was talking about. We can all agree. Okay? But based upon their racial, ethnicity, and genealogy test, his family goes back to his paternal side, Kushner family, and his maternal side, the Clan McLeod family. Okay? Everyone sees that. No one talks about that. No one is addressing that in regards to citizenship based upon the executive order 14160, because that deals with paternal biological ancestry, which was enacted by an executive order. Had nothing to do with their understanding of citizenship. Trump knew that and clearly understands that. Okay? That's why they're upset with him. So he's connected to the Clan McLeod and Kushner family. All right? I'm not concerned about the Kushner family because he didn't take his descent based upon his office. He took it from the Scottish family or the Nordish family because the Scottish and Nordish family are all related. Clan McLeod. his mother's side. Clan MacLeod is a Highland Scottish clan. You hear that? Associated with the Isles of Skye, Isles of Man. There are two main branches of the clan, MacLeod of Harrison, Dunvegan, known as Gaelic as Sinon Tomid, seed of Tomud, and clans MacLeod of Lewis, as sits in Razay, known in Gaelic as Sigtukul, seed of Tukul. Both branches claim descent from Leod of North Gael, who lived in the 13th century. Everyone understands that? Okay? Very, very, very important for you to understand that. The surname MacLeod means son of Leod. The name Leod is an Anglicization of the Scottish Gaelic name Leod, which is thought to have been derived from O North. Clan means children of the family, offspring, descendant in clan. Did you hear what I just said? So we're going through the descendants of Donald Trump, whether it's German or Scottish or Old North, that is his bloodline. It didn't care about it in the National Security Act of 1790 because that's not the intent of the political structure that was established at that particular time. Okay, as well as the present. Okay, this cannot be overlooked. The clan MacLeod of Lewis claims its descent from Leod, who according to MacLeod tradition was the younger son of Olaf the Black, King of Man, called the Isles of Man, okay, which is right now overseen by the kings of the United Kingdom, Charles III, okay. So the MacLeod family or the clan MacLeod, Donald Trump's mother's or descended down from Olaf the Black. Let's look at Olaf the Black. Olaf the Black. Olaf Gurson, also known as Olaf the Black, was a 13th century king of Owls and a member of the Corvan dynasty. He was the son of Gur Olafsson. Okay, very important. What's important is that they called him Olaf the Black, characteristics of who he was, versus Olaf, the surname or the family name. Okay, very important because Donald Trump family claimed they descended down from Olaf the Black through the MacLeod family, which were Scottish kings, all right, which also descended down from Old North, Nordic, Vikings, okay? Now we know they tied into the family by way of invasion, conquest, as well as marriage, okay? Very important. So Olaf the Black was also called Olaf Gurson. So just look at that name, Olaf. What does the word Olaf mean? Behind the name Olaf. Olaf from Old North is the name Elif, meaning ancestor or descendant, derived from the elements of Anu, ancestor, and Leif, inherited or legacy. This was the name of 5 kings of Norway, including Saint Olaf. Now we know Anu is a Samaritan deity as well, or Phoenician, and we know that when we go back into, matter of fact, I might go pull it up. The Phoenician origin of Britain, Scots, and the Anglo-Saxons. The Phoenician origin of Britain, Scottish, and the Anglo-Saxons. All right, very important. Some of you might have this book, some of you might not have it, but I suggest you get it. This goes in history of Brutus of Troy, Albion, Alba. I talked about that in my last lesson. So if you didn't watch my last lesson, you need to go back and revisit it because it'll bring clarity into this lesson. Okay. Also, I talked about the MS Scroll 1066, MS Roll 1066, that qualifies the story of Brutus of Troy. And this book called The Phoenician Origin of British, Scottish, and the Anglo-Saxons. It says, thus the daring Phoenicians, pioneer mariners who expended courage in their small-winged galley, first explored the wide seas and confines of the unknown ancient world, and of whose great contributions to civilization of Greek and Roman classic writers speak in glowing terms were I found by indisputable inscriptional and other evidences, not Semite as heard to suppose, but were Aryans in race, speech, and script. They were besides disclosed to be the lineal blood ancestors of the Britons and the Scots, properly so called, that is, as opposed to the aboriginal dark non-Aryan people of Albion, Caledonia, Hibernia, and the dusty small stature pigs in kindred Iberian tribe. So we see in this book, they said that the Iberians or the Hibernians or the Albion or the Caledonia or the Picts or the Celtics were different from the Aryan race. Okay, very important. Which those who immigrated from the Mediterranean at the time of Brutus to Troy, when Rome had left the invasion of what we call Albion, also called Britain, goes back to what we talked about: Alexander, Kenneth McAlpine, Alexander II. We talked about all of this in my past lessons. So if you have not reviewed it, you need to go back and watch it to get an idea of who these people are in regards to not based upon the color of skin, but based upon the genealogy, ethnicity, which was all denoted by their character. Okay, their characteristics. Okay, so with that in mind, let's get into the. Let me go back here. All right. Olaf the Black. We know Olaf means Anu or ancestor, Anu leaf ancestor or inheritance. So we're talking about an inheritance based upon an ancestor, okay? All right, and we're saying that Clan McLeod, which Donald Trump claimed to send down from, are living off the virtues of somebody who they claim to be their ancestors, but are really not because the names don't match. If they really had an ancestor, then the Nazis Act of 1790 should have been based upon the ancestry and not based upon some color skin denoting to those of Aryans, i.e. white or Caucasoid. Okay? We must make that distinction. I'm not racist. I'm just giving you the facts. The meaning of the word Olaf means Anu or Alifa, which means inheritance or what's that? Let's go back to it again. Alifir. Let me see this show. Remember the movie Olaf the Snowman? A Nordic resemblance of Olaf. All right, very important. Olaf, root word, Anu and leaf. Okay? Olaf, root word, Anu and leaf, which means, as we go back here, Olaf, from the Old North name Alifir, meaning ancestor or descendant, derived from the elements Anu or ancestor and leaf, inheritance or legacy. This was the name of 5 kings of Norway. Okay, very important to understand that. All right. So they call him his name Olaf the Black. Now we know his name Olaf, which means inherit ancestor and inheritance or legacy. What's up with the black? Because it didn't say it said his name was called Olaf Gurson. Okay. Olaf the Black or Olaf Gufferson. All right, let's go back there real quick and look at it before we go out to the origin of the name. Because apparently Donald Trump and his family, the line, the genealogy don't match up. Olaf the Black or Olaf Gurson. Okay, that's an Old Norse spelling of an English word. So what is the Old Norse spelling of the English word, and what is the translation from the Old Norse into English, and what does that name say? Let's see. Because apparently, if we're going based upon ancestry, that means that Donald Trump are claimed to be descendants of Olaf Gufferson based upon the English name of how we interpret the Old North language. All right. But apparently, Olaf the Black, and we know black is a noun. Okay. I mean, adjective. Black is describes something. So Olaf the Black, that snowman was not black. Okay. That snowman, Olaf, was not black. Can everyone agree? Olaf Gufferson. So let's look at the word. We know son is a prefix. So Olaf the Black was called Olaf Gura, son of Gura. Okay? Son of Gura. Let's look at it, brothers and sisters. Olaf Gura. G-U, whatever letter that spells, but look like that's like an O with a cross on it, right? Gender, masculine. Usage, Old North. Varied or Grafur. All right, other languages. Godfrey, 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 Jeffrey, Jeffrey, Geoff, Jeff, Jeffrey, Jeffrey. So meaning that Olaf the Black was in fact Olaf Jefferson or Olaf the Black Jefferson. And we can clearly see that Donald Trump or his descendants who descended down from Olaf the Black or Olaf Gurson was not descendants of Olaf Jefferson, because that's what the name says. Okay? I didn't put this here. Can everyone agree with me? Or if anyone disagree or agree with me, give me a thumbs up in the chat line or a thumbs down in the chat line. Doesn't make a difference to me. So if it says the Old North name that we're looking at is in English Godfrey, let's look at the name of Godfrey in English or Jeffrey in English and see if it correlates with the Old North in translation. Let's see. Godfrey. This is how you do the knowledge. Godfrey. From a Norman French, from a Frankish name, the second element of O is freedom, peace, while the first element could be Geet, North German tribe, Gawi territory, or Walla foreigner. And we understand that Trump is German as well as Old North or Scottish descendant. All right. Let's look at the word Godfrey and Old North. And what does it say? Right here. Same word. Do everyone see that? Do everyone see that? Godfrey is the same word in Old North as Gafur or Gura. All right? Let's get another spelling. Jeffrey, just to be on the safe side. Look it up in Old North. It's the same translation, my brothers and sisters. So that's safe to say that Trump and his ancestors are claiming to descend down from my family. Is that safe to say? if we want to play that game, if they want to play that game. All right, so now let's go to the cases. You know, I always say the best for last. Everybody still with me, or did everybody go to sleep? If everyone's still with me, give me a thumbs up in the chat line. All right? Supreme Court of the United States. Let's get it. Let's see what they got to say about the King of England and the English people. Y'all, let's see what they say. No one else is talking about what the Supreme Court said about us, but I'm going to tell you. No one's talking about what the Supreme Court said about who the true citizens are and what the true intentions of the Executive Order 14160 is. But I'm going to show you they're talking about the English people. They're talking about the English king when he comes back. All right? And guess what? I am back. Supreme Court recognized that I have the power. So let's talk. When you go tell anyone out there talking about the decision in the Supreme Court and the effect that it has on, i.e., people who are assumed to be citizens. See if you fit into the category of a true citizen as established by what the Supreme Court said. Not by what you think a citizen is, because they never addressed that fact. They only addressed the matter in regards to the three parties in the matter in regards to national injunctions, and they don't have that authority, especially in regards to the injunction benefiting so-called immigrants, okay? To stop Trump executive order from deporting immigrants who claim to have a right to an injunction on behalf of a class of people. Supreme Court of the United States syllabus. Trump, President of the United States, class action versus CASA Incorporated, ETAL. Plaintiffs, respondents here are individuals, organizations, and states filed 3 separate suits to enjoin the implementation of the enforcement of President Trump Executive Order 14160, which we just talked about. Okay? We just talked about the Executive Order 160. C, protecting the meaning of the value of American citizens. The executive order identifies circumstances in which a person born in the United States is not subject to the jurisdiction thereof, is thus not recognized as an American citizen. Now, we're not going to go through the whole and read the whole case. I just highlighted certain aspects about the case that need to be to have the people brought up to speed. The application does not raise, and thus the court does not. Part so. Let me just highlight this one. All right, sorry. The government argues that the district court lacks equitable authority to impose universal relief and has filed 3 nearly identical emergency applications seeking partial stays to limit the preliminary injunction to the plaintiff in each case. The applications do not raise, and thus the court does not address the question whether the executive order violates the Citizenship Clause or Nationality Act. So they don't rate or give a dissent on whether the executive order violates the Citizen Clause or Nationality Act. All right. Instead, the issue of the court decides on whether, under the Judiciary Act of 1789, federal courts have equitable authority to issue universal injunctions. That's what the court dealt with. Okay. Page 2. It was held. Universal injunctions likely exceed the equitable authority that Congress has given to federal courts. The courts grants the government applications for a partial stay of an injunction into below, but only to the extent that the injunctions are broader than necessary to provide complete relief to each party withstanding to sue. So you must bring a complaint in regards to the class action based upon your purport. Okay, if you don't raise the argument, then the argument is waived. Okay, there is no such thing as a universal injunction on a natural injunction because the law, the court, the history does not go back far enough. The Supreme Court is going to justify that. Let's see. Universal injunctions are not sufficiently analogous to any relief available in the courts of equity in England at the time of the founding. Group versus Mexicano. I read that case. Once again, universal injunctions are not sufficiently analogous to any relief available in the court of equity in England at the time of the founding. Equity offered a mechanism for the Crown to secure justice where it would not be secured by the ordinary and existing process of the law. Once again, equity offered a mechanism for the Crown to secure justices where it would not be secured by the ordinary and existing process of the law. The Origins of England Equity, 16 column, L. Revised, 8791. This judicial prerogative of the king thus extended to those causes which the ordinary judges were incapable of determining. You hear that? Eventually, the Crown instituted the practice of delegating the cases that came before the judicial prerogative to the Chancellor for his sole decision. Do everyone understand why they don't want this matter to get out? Because it's not the authority of the congressional or legislative branch to say so. It is the authority of the king because the king is the head of the executive department. It's king and his council. Then it's king and his parliament. That's the legislative branch. Then it's king and his bench. The king and the judiciary. Okay? So they understand that universal injunctions can only be raised by the Crown on behalf of the king, thus extended to those causes where the ordinary judges were incapable of determining. Did you hear that? All right. Now let's see how the Supreme Court elaborates even more on the subject matter in regards to citizenship, overlooking the points that I raised in this lecture. Okay, let's go here. I can't see what page I'm on. Oh, here we go. Page 4. Unlike universal injunctions, however, which reach anyone affected by executive or legislative actions, bills of peace involve a group that was small and cohesive. And unlike universal injunctions, which bind only parties to the suit, decrees resulting from a bill of peace will bind all members of the group, whether they were present in actions or not. So a motion for a preliminary injunction or a national injunction can only be raised by parties coming within their purport. Okay? We call them a bill of peace, which can be brought by one individual on behalf of all individuals of that class. Okay? Which is validated by the Supreme Court. Okay? Very important that you understand. Page 11. Bear with me. One. It says specifically, it sets forth, they're talking about the arguments raised by the one second, hold it. It says specifically, it set forth the policy of the United States to no longer issue or accept documentations of citizenship in two scenarios. One, when a person mother was unlawfully present in the United States, and the person father was present in the United States, and the person's father was not a United States citizen or lawful permanent resident at the time of the said person's birth. Or two, when a person's mother presence in the United States was lawful but temporary, and that the person's father was not a United States citizen or lawful permanent resident at the time of said person's birth. The executive order also provides for a 30-day ramp-up period. During that time, the order directs executive agencies to develop an issue of public guidance regarding the order's implementation. The plaintiffs filed a suit alleging that the executive order violates the 14th Amendment Citizenship Clause, i.e. codified as Title 8 United States Code 1401, which is known as the Nationality Act of 1940. So the Nationality Act of 1940 is codified as Title 8 United States Code 1401, which is totally different from the 14th Amendment. Okay? Based upon it looked at in light of the common law as well as the history where the common law originated from. All right? So Supreme Court never addressed that. Anyone who's given a narrative of the Supreme Court decision did not discuss that. As a result of that, I have to discuss it for you. The government has now, I'm sorry. The government has now filed 3 nearly identical applications seeking to partially stay the universal preliminary injunction and limit them to the parties. See application for partial state injunction in number 24, 8884, 885, and 886. The applications do not raise, and thus we do not address the question whether the executive order violates the Constitution. Violates the Citizenship Clause, not Constitution. Pardon, sorry about that. Violates the Citizenship Clause or Nationality Act of 90? The issue before us is one of remedy. Whether under the Judiciary Act of 1789, federal courts have equitable authority to issue universal injunctions. 2, the question whether Congress has granted federal courts the authority to universally enjoin the enforcement of an executive or legislative policy plainly warrants our review, as members of this court have repeatedly emphasized. So it's justified for them to reveal based on by the petition raised by the party in lieu of questioning if the executive order actually violates the 1790 Naturalization Act, I mean not 1790, of the 1940 enactment, all right, that governs Title 8 United States Code 1401, having nothing to do with the common law of England. That argument they are actually staying away from. We must understand that. They're going to stay away from that argument. We're not, though. We're not. When you raise this argument coming within that purport, you get different results. It is easy to see why, by the end of Biden's administration, we have reached a state of affairs where almost every major presidential act, I'm sorry. Every major, it was easy to see why by the end of Biden's administration, we have reached a state of affairs where almost every why every major president act was immediately frozen by a federal district court. W. Ball and S. Brake, comments, proper parties, proper relief, 137 Harvard, L. Revised, 152, 174, 2023. The trend has continued. So they're saying that the district court has continuously supported invalid or unconstitutional presentments to the district courts on behalf of parties knowing darn well that the actual argument raised in them shouldn't have been justified by those district courts, especially in regards to a matter such as this. The government is likely to succeed, then they say in part 2, the government is likely to succeed on the merits of its argument in regarding to the scope of relief that the government requests. All right? So they're letting them know that based upon the argument raised by the government seeking relief from those who denying the president from issuing executive order in regards to the authority that was authorized by the Constitution, okay? He does have this power to make these decisions, okay? He does have the power to make these decisions. Let's see. The Judiciary Act of 1789 endowed federal courts with the jurisdiction over all suit and equity. And still today, this statute is what authorized the federal courts to issue equitable remedies. Though flexible, the equitable authority is not free-willing. We have held that the statutory grant encompasses only those sorts of equitable remedy traditionally accorded by courts of equity at our country's exception. So the different methods for granting equitable remedy is different from these courts and the courts that preceded the courts that are now active. Okay, the equity jurisdiction conferred on the federal courts is the same. Once again, the equity jurisdiction conferred on the federal court is the same It's the same as the High Court of Chancery in England, possesses. So once again, I repeat, it says the jurisdiction conferred on the federal courts is the same that the High Court of Chancery in England possesses. You hear that? We must therefore ask whether universal injunctions are sufficiently analogous to the relief issued by the High Court of Chancery in England at the time of the adoption of the Constitution, and that the enactment of the original Judiciary Act. Did you hear that? Did you hear that? The High Court of Chancery in England, we must therefore ask whether the universal injunctions are sufficiently analogous to the relief issued by the High Court of Chancery in England at the time of the adoption of the Constitution and the enactment of the original Judiciary Act, because they are the same as the federal courts. That's what it just said. That's what it just said. If I'm not mistaken. The equity jurisdiction conferred on the federal courts is the same. It's the same as that of the High Court of Chancery in England possesses. We must therefore ask whether universal injunctions are sufficiently analogous to the relief issued by the High Court of Chancery in England at the time of the adoption of the Constitution and the enactment of the original Judiciary Act of 1789. Did y'all hear that? Did y'all hear that? I hope someone heard that. All right? They're making decisions in the federal courts and in the Supreme Court based upon a matter that should be heard in the Chancery Court based upon English overseas authority. Okay? We must understand that the High Courts of Chancery in England possess the same authority that our federal courts have, and the decisions that they made in the Chancery Court of England, they're going to make in these courts we have today. All right? It's right there. It's right there. Let's go a little bit further. Loud and clear. Let's see. Listen, y'all. The origins of English equity. Now, this is the Supreme Court saying this. Eventually, the judicial prerogative of the king thus extended to those causes which the ordinary judges were incapable of determining. That, they said that twice. Okay? They said it twice. The judicial prerogatives of the king thus extended to those causes which the ordinary judges were incapable of determining. Who are the ordinary judges? The judges that they are talking about right now. Them. They are the ordinary judges. They can't decide these matters. Why? Because it's outside of their authority. Eventually, the crown instituted the practices of delegating the cases that came before the judicial prerogatives to the chancellor for his sole decision. This became the common mode of dealing with such controversies. Did y'all hear that? Of importance here, suits and equity were brought by and against individual parties. You hear that? Individual parties. Suffice to say, then under long-standing equity practice in England, there is no remedy remotely like a national injunction. All right? So you can't invoke no national injunction, especially in the king's court, because the king or the chancellor is the only one who has authority. We can go to Edinburgh versus Chancellor for that. That goes back to Viscount Cornbury and what's his name? The first Welsh governor, William Franklin. They kept the justices in check. Okay? Very important to understand that language on the extent of the judiciary power. Let's continue. And in ensuing decades, we consistently rebuff requests for relief that extended beyond the parties. The benefits of the court's injunction improperly extend to bidders throughout the nation who were not parties to any proceeding, who were not before the court, and who had not sought no relief. Okay? So if you're not a party in regards to the claims brought forth in their purport, then you ain't gonna get no remedy. How could the state claim a national injunction and they're not the one who want the injunction? They want the injunction on behalf of their citizens, but the citizens ain't raising the argument. Nowhere in any case brought within the review of the Supreme Court was it brought forth on behalf of a citizen. All right? It was the state, it was the individual, it was the corporations protecting their types of citizens that don't deserve the protection because they are, in fact, immigrants. They are outside of the law. Okay? We must understand the language of the Supreme Court. They're going to go deeper. Let's see. Justice Sotomayor going to go off. Let's see. Let's get to it. Let's get to that. We're gonna go ahead and we're gonna close out. What page is this? Page 54, and we'll close out on that. Chief Justice Sotomayor. I think her dissent is the most courageous. Her dissent. All the rest of them were scared, but Sotomayor, she kept it real. So I'm only just going to read hers. Bear with me, everyone. Let me just find it. I can't get this thing removed. Chief Justice Sotomayor. She went in. Not Kavanaugh, not just Alto, but just Sotomayor. You can download the case yourself and do the research, but I'm only interested in her dissent. It's 119 pages for anyone concerned. Can't see what page it is. Here we go. Chief Justice Sotomayor. All right. We're going to close out on her dissent. Supreme Court of the United States, page 54, Donald Trump, President of the United States, ETAL versus CASA. Nope. Everyone ready for this? Y'all should be jumping for joy. Justice Sotomayor, with whom Justice Kagan and Justice Jackson joined by the center. All right, this is for all of you. Justice Sotomayor with Justice Kagan and Justice Jackson joined the center. Children born in the United States and subject to its laws are United States citizens. That has been the legal rule since the founding, and it was the English rule well before then. I repeat, children born in the United States and subject to its laws are children born in the United States and subject to its laws are the United States citizens. That has been the legal rule since the founding, and it was the English rule well before then. Did you hear that? Once again, the children born in the United States and subject to its laws are United States citizens. That has been the legal rule since the founding of the United States or the states or any states for that matter. It was the English rule well before then. Does that make sense to everybody? This court once attempted to repudiate its holding and the Dred Scott case that the children of enslaved Black Americans were not citizens. To remedy that previous error, the state passed in 1866 and Congress ratified in 1868 the 14th Amendment Citizenship Clause with enshrined birthright citizenship. in the Constitution. There it has remained accepted and respected by Congress, by the executive, and by the courts until this day. All right? It is now the president who attempts in an executive order or citizenship order to repudiate birthright citizenship. Every court to evaluate the order has deemed it patently unconstitutional and for that reason has enjoined the federal government from enforcing it. Undeterred, the government now asks the court to grant emergency relief, insisting it will suffer irreparable harm unless it can deprive at least some children born of United States citizenship. You're right. United States citizenship separated from American citizenship is not synonymous. You're absolutely right. The government does not ask for a complete stay of the injunction as it ordinarily does before the court. Why? The answer is obvious. To get such relief, the government would have to show that the order is likely constitutional. An impossible task in light of the Constitution's text has text history, this court, presidents, federal law, and executive branches practices. So the government instead tried its hand at a different game. It asked this court to hold that no matter how illegal a law or policy, courts can never simply tell the executive to stop enforcing it against anyone. Instead, the government says it should be able to apply citizenship orders whose legality it does not defend to everyone except the plaintiff who filed the lawsuit. Did you hear that? I'm going to read that again. The government does not ask for complete stays of the injunction as it ordinarily does before the court. Why? The answer is obvious. To get such relief, the government would have to show that the order is likely constitutional, an impossible task in light of the Constitution, text, history, this court, presidents, federal law, and executive branch practices. So the government instead tries its hand at a different game. It asks its courts to hold that no matter how illegal a law or policy, courts can never simply tell the executive to stop enforcing it against anyone. Instead, the government says it should be able to apply the citizenship order whose legality it does not defend to everyone except the plaintiffs who filed the lawsuit. The gamemanship in this request is apparent and the government must not attempt to hide it. Did you hear that? Yet, shamefully, this court plays alone. A majority of this court decided that these applications of all cases provide the appropriate occasion to resolve the question of universal injunction and end the century-old practice once and for all. In a rush to do so, the courts disregard basic principles of equity as well as the long history of injunctive relief granted to non-parties. No right is safe in the new legal regime the courts creates. Today, the threat is to birthright citizenship. Tomorrow, a different administration may try to seize firearms from law-abiding citizens or prevent people of certain faiths from gathering to worship. The majority holds that absent cumbersome class action aren't so. Hold on, guys, 1 second. It's doing mouse of mine. This is the majority holds that absent cumbersome class action litigation, courts cannot completely enjoin even such plainly unlawful policies unless doing so is necessary to afford the former parties complete relief. That holding renders constitutional guarantees meaningful in the name only for an individual who are not parties to a lawsuit, because I will not be complicit in so grave an attack on our system of law and I dissent. Let's go back a little further. B. Unsurprisingly, given the clarity of the Citizenship Clause text, every other source of interpretation confirms this conclusion. Consider the first its history. Long before the 14th Amendment, listen, y'all. Y'all better listen. Long before the 14th Amendment, and indeed before the founding, the common law rule of George soil, liberty, right to the soil, governed English citizenship. You hear that? English citizenship, not American citizenship. English citizenship. That rule rendered a person's birthplace determinative of her citizenship status. Thus, the children of aliens born in England generally were natural born subjects and entitled to all the privileges of such.